Thank you everyone for coming in. It's my pleasure to introduce Professor Jeremiah Ho. Professor Ho teaches contracts, trusts, and estates, remedies, products liability, and law review note writing, and writes about law and inequality, exploring such issues mostly concerning sexuality, race, and culture. He also writes extensively on legal education, pathology, and theory. Professor Ho has won respect and admiration of his students and faculty, colleagues alike. In 2014, he was selected for the Lawyers of Color's 50 Law Professors Under 50. He's also received the Professor of the Year Award 4 times in 2016, 17, 18, and 19, and most recently was awarded the 2020 Manning Prize for Excellence in Teaching for outstanding dedication to his students and to the university. Very excited to have you here. Can't thank you enough, and very excited for the presentation.
Thank you so much. Thank you. So I really appreciate being invited here. Hello and good afternoon, everyone. I'm very happy to be part of this Corsair Chat. Thanks to everyone at the university for having me, and happy homecoming 2020. Many of you know that I teach at the law school, and so I do want to talk a little bit about the law school before I go into my Corsair chart. I've been here since 2012, and when the law school was just barely 2 years old in existence, it was still in toddler form. Since then, we've settled into a comfortable position as the Commonwealth's first and only public law school. And this year, we've reached our 10th year. So now we're kind of heading into the preteen era. We're fully accredited in 2016 by the American Bar Association. Our student body has grown since the last 10 years as well. We've had some national recognition in several key areas of the law school, including our recent admissions rates, our recent bar passage rates, our recent faculty scholarship, and our public interest specialties that effectuate original access to justice mission. So I've been very proud of being part of the institution and proud to work as a law professor at UMass. I'm also very proud that the Dartmouth campus has served the public, the Commonwealth, as the public university in the South Coast area. So as a law professor, I teach first-year contracts, but I also write about how the law affects the lives of people of color and people from the LGBTQ community. And as an outsider coming into Massachusetts, I'm admittedly originally from California, I'm truly amazed by the unique political and legal landscape that has made Massachusetts first in many legal and social advances in our modern democratic society. I'm sure as New Englanders, you often hear that Massachusetts is a progressive blue state, and perhaps have intuited what that might mean. That Massachusetts itself has been this place where democratic values have been breathed into the ether. But perhaps you might not have known exactly how Massachusetts, as a dynamic place for American democracy, has actually influenced and led the way that the law on certain social issues have developed on the national stage. So the subject of my Corsair chat today is what Massachusetts LGBTQ advancements have taught us about equality in our laws affecting marginalized people. Hopefully by the end of this chat, you'll see both the dramatic and the subtle ways in which Massachusetts has had a hand, a very important hand, in helping the rest of the country process through some important, significant social issues. And perhaps you'll learn a little bit more about how Massachusetts engaged in the national dialogue regarding what makes our laws constitutional or not, and you'll be proud of being part of Massachusetts. Before continuing, I do want to thank my law librarian, Emma Wood, for her special skills at putting together some research for me for this particular chat. So thank you, Emma, if you're out there. So I'll start with what seems like a no-brainer statement that might be something you'd find in a civics lesson for school children about the guarantees given by the Constitution, that our laws ought not to embody stereotypes of different people, but instead ought to focus on how to elevate the lived experiences of those who haven't been able to access equality within our legal and political systems. This is so basic that you might think at this point in our history Of course, it's not right for our laws to be written to reflect stereotypes of certain people. But do you know how novel this idea actually is? It's only been about 100 years since social scientists have begun studying the phenomenon of stereotypes. And in fact, when the Civil Rights Act of 1964 and the case Brown versus Board of Education case that came out in the mid 50s, most of those kinds of regulations or those kinds of judicial decisions dealing with discrimination were dealing with overt acts of discrimination, the kind of exclusion of people from a part of civil society based on some targeted characteristic that they carry, either the color of their skin, their gender or sex, their nationality, their religion, and less so about the discrimination that are based on stereotypes. So this is actually a fairly new study in the area of social sciences and law and political systems. So it's only been a few decades since that certain legal circles have begun to address the more hidden ways that our rights are often assaulted by laws that embody stereotypes. In hindsight, given so much attention today about stereotypes, it's often very surprising even to my students. Now, why is it very important that our laws ought not to reinforce stereotypes? Well, it's because stereotypes often serve the purpose of reflecting common misperceptions and biases against particular groups of individuals. If one acts towards another person based on stereotypes, that's one case of bias against another person. And we can recognize this instance of bias as being wrong. But if our laws embody and reinforce common stereotypes and biases against certain groups of people, then it creates aggregate instances of discrimination. And this aggregate effect then creates the institutional and structural biases that we've been hearing a lot about, especially since the racial reckoning that's happened nationally this past summer. At the same time, we should also have intuited or know that this idea of equality and fairness in our laws that tend to reflect how everybody should be treated equally is often really hard to accomplish, because in reality, some groups and societies don't start off equally as everyone else because of stereotypical laws that create systemic inequality that keeps us from showing or effectuating that reality. Our laws need to focus more on bringing people up to equal footing in order to reflect that value of equality. Now, Massachusetts has always been at the forefront of progressiveness in our laws. For instance, on the issue of slavery, the Supreme Judicial Council, the highest court in Massachusetts, in 1783 determined that slavery in Massachusetts was unconstitutional. Now, this was 82 years before slavery was considered unconstitutional federally under the US Constitution. And more recently, in 2006, Massachusetts enacted a comprehensive healthcare reform that had a core purpose of providing healthcare to all of its citizens. The structure of both the legislative and the judicial bodies in Massachusetts have had an influence for sure, but so has the ideology of its citizenry. And this ideology that has affected, and it's this ideology that has affected how we nationally see the flaws in our stereotypical laws. Now, I want to focus on the Goodrich case from 2003, 2004 to show you how the context of marriage equality, that Massachusetts was the first state having this particular case that made a difference in combating stereotypes against LGBTQ people in the law, and how beyond its record as the first marriage equality case in the country, Massachusetts actually went deeper to affect the national conversation on stereotypes against gay people and same-sex relationships. Now, the Goodrich case, I'm just going to give you a little bit of background on the facts of the Goodrich case, but the Goodrich case in my mind is very similar to the Obergefell case that came to the Supreme Court a decade later in 2015, the most famous marriage equality case, the one that nationally recognized marriage equality. The Goodrich case is the first of its kind on the state level. It was the first in the country, but the facts are very similar. So I often see that there is factual overlap between these two cases. And the facts goes like this. There were 7 same-sex couples in Massachusetts in the Goodrich case who were denied marriage licenses, and then they sued the Department of Public Health. They lost at the trial level, and they appealed directly to the SJC. The SJC, again, being the Supreme Judicial Council, the highest court in Massachusetts. And then the SJC reversed the trial court's decision, thus legalizing same-sex marriages in 2003. Now, believe it or not, there are different ways that an appeals court that wanted to legalize marriage equality could have rationalized this decision. There are many different ways to get to that particular result. One really easy way would be to argue that obvious type of discrimination, the type of discrimination we saw in the Brown versus Board of Education case, that this subset of the population was excluded from equal treatment and how that's consequentially unfair and should be changed. But the Massachusetts Supreme Judicial Council did something quite extraordinary. Not only did it address that kind of exclusion, it also called out the stereotypes that created these kinds of exclusions, both overt types of stereotypes and the hidden kind of stereotypes that were lurking within the law here and served mostly to marginalize same-sex couples, but sometimes also seemed to marginalize opposite-sex couples too. So let's take a look to see how the SJC dealt with these types of stereotypes, and beginning with the overt stereotypes first. There were 3 overt stereotypes that were at issue in the Goodrich case that were addressed by the Supreme Judicial Council. The first one was that marriage is only for procreation. And the court said here, well, there are many opposite-sex couples who marry and don't have children, so this is a stereotype. And then also people can and do have children in other ways through adoption, for instance. So that stereotype is not something that's viable to support any kind of legal exclusion of same-sex couples from marriage in this instance. The second stereotype is that all children need a set of opposite-sex parents in order to thrive, and marriage facilitates this need. Well, the court said here, well, what about single families and alternative parenting? Those are also very valid forms of having families and child rearing as well. And also, in some very, very subtle ways, this stereotype seems to affirm traditional gender stereotype roles in opposite-sex marriages, which may marginalize women over men. So in this case, the stereotype here also affects opposite-sex couples in a way that could be marginalizing as well. So this stereotype was found to be not valid to support any exclusions of same-sex couples from marriage in Massachusetts. And then the third overt stereotype was that gay couples are wealthier than straight couples, so they don't need marriage benefits. And the court said that's not quite true. Actually, the demographics are actually very similar between same-sex couples and opposite-sex couples in regards to finances. Gay couples also have financial dependence, just like straight couples. They pay the same kind of bills. And also the question was posed by the Supreme Judicial Council, since when is financial dependency a requisite for marriage? So in this regard, stereotype number 3 was also found to be not strong or worthy or true to be able to continue to allow the legal exclusion of same-sex couples from marriage. So these are the ways in which the SJC dealt with the overt types of stereotypical discrimination created by misconceptions about LGBTQ people. But there is one more thing that the SJC did in Goodrich that has become very influential a decade later, especially at the Supreme Court. The SJC here also addressed how the laws denying same-sex marriage and the way it has been interpreted reflect a stereotypical view that gay people are immoral and would thus threaten the sanctity of marriage. And this is the hidden stereotype that I was talking about, that the court, in its very exceptional decision, decided to take up and address. This is the harder stereotype to unpack and unwind. So with this one, again, the court was looking at a hidden stereotype. Gays are immoral and thus would threaten traditional marriage. And let's see how the SJC tried to find that this is a stereotype not worthy of being part of the buttressing of the law here. First, the court said that gay people are not outsiders, but normal human beings. And we'll see in a little bit how the court did this. And secondly, the court said same-sex couples are seeking marriage not actually to threaten it, but to strengthen marriage because of their commitment to being in relationships and their commitment to family and child rearing and such. And then thirdly, the Supreme Judicial Council found that because of the first and second premises, exclusion from marriage creates a second-class citizenry that would be unconstitutional in Massachusetts. Now let's explore these 3 points a little bit more in-depthly. The court here, in the first instance, in the first premise, gay people are not outsiders, but normal human beings. The court actually tried to humanize the plaintiffs here by saying they're not outsiders. The plaintiffs here who are seeking to be married, but they're same-sex couples, include business executives, lawyers, investment bankers, educators, therapists, computer engineers. They're active in their church, their community, their groups. They're contributors to society in every single notion that's comparable to people who are not gay. And secondly, the court said a decision that same-sex couples don't threaten marriage. In fact, the plaintiffs seek only to be married, as the court writes, not to undermine the institution of civil marriage. If anything, extending civil marriage to same-sex couples reinforces the importance of marriage because these couples are committed to each other and also they're committed to their families. And lastly, because of the first and second premises, marriage exclusion creates a second-class citizenry if the exclusion bars people like the plaintiffs here from being able to partake in the licensing of their relationships and marriage. Without the right to marriage, one is excluded from the full range of human experience and denied full protection of the laws. Now, this is actually at the time quite earth-shattering and very difficult to have harnessed and put into a decision, because to find hidden stereotypes in the law, you have to really go deep and you have to do a lot of really careful analysis to pull out that hidden stereotype and then address that stereotype, to debunk that stereotype, and then show how this hidden stereotype has actually affected a group of people, marginalized a group of people in some really interesting but hard and unconstitutional way. So let's take a look at how this affected the Supreme Court's version of marriage equality cases about a decade later. So cut to 2015, and we have the Obergefell case. And this is the case that's dealing with same-sex couples and marriage on a national level. And here, what I would say is that Justice Kennedy, who's now retired, has a similar rhetoric. At this point, in 2015, about 10 years later, a lot of the overt discrimination or a lot of the overt stereotypes have been ironed out over a series of state cases and over a lot of the political campaigning that has happened with a lot of grassroots campaigns for marriage equality. So the three overt stereotypes are now pretty much off the table. And now what we're dealing with is the hidden stereotype that now the court here has to address, the Supreme Court of the United States, that is. And here, the court uses the same three premises that was started by the Massachusetts case. First, gay people are not outsiders, but normal human beings. This is what Justice Kennedy says, and he uses illustrations from the litigants' lives, just like the Supreme Judicial Council did in the Massachusetts case. Secondly, the Supreme Court said same-sex couples are non-threatening to marriage, and used similar language as the Massachusetts case. Far from seeking to devalue marriage, the petitioners seek it for themselves because of their respect and need for its privileges and responsibilities. They're committed in these relationships to their families and to themselves, and therefore having them be able to partake in marriage would not threaten marriage, but really strengthen it instead. And lastly, the Supreme Court also said that because premises, marriage exclusion creates second-class citizenry. Again, that's very similar, if not identical, to what we saw in the Goodrich case from Massachusetts. Here, the court said by virtue of the exclusion from marriage, same couples are denied the constellation of benefits that the states have linked to marriage. So this is quite interesting that 12 years later, you have the highest court in the land borrowing from the first case at a state level that was promulgated by Massachusetts here. And I teach law classes, and if I saw this on two people's different final exams, I would probably swear that this was cheating. But we're not in the classroom, and this is not the same kind of test. This is a test of national consciousness, and of course this borrowing is totally allowed. So again, just merely in the marriage equality context, Massachusetts was able to be the first to address stereotypes in the law that aggregate to create systemic inequality. And it's this influence that went up to the national level when the Supreme Court took up the exact same rhetoric in 2015. And with marriage equality as an example, we actually see how Massachusetts has also more broadly contributed to illustrating how our laws can systemically marginalize people by embodying views that reinforce stereotypes. Stereotypes against marginal people are often cemented into the law. And in effect, these laws create second-class citizenry against lived experiences of different people. And lastly, aggregating this kind of effect creates the kind of systemic inequality that we've been talking about nationally for quite a while now, but especially since the last summer. And it's in this age of social and political questioning and upheaval that it's super important for us to see how our laws can reflect our implicit biases and stereotypes, how such laws aggregate to create second-class citizenry and then become part of the system of our politics and of our laws. Studying what Massachusetts has done in marriage equality informs other political movements against inequality, particularly movements that might help racial groups overcome systemic or institutional hierarchy. Structural inequality is heavily tied to stereotypes that are cemented into the law. And we do need to find ways in which to, not for the lack of a better word, divorce those stereotypes from the laws that we have in our land in order to effectuate the values of equality that we hold dear to our hearts. So with that, I hope with this quick presentation, you see how important Massachusetts has been on the national stage. And I hope that you can feel proud that this is a state that carries the democratic project forward in a very meaningful way. Here at UMass, we believe in the values of diversity and inclusion. Homecoming is a tradition that allows us to pause and reflect on our values as an institution, a public institution in the Commonwealth. And at the law school here at UMass Dartmouth, this type of examination of the law is our commitment, whether in the classroom or in our public service works. my presentation here serves as a revisit of that core value and as a demonstration of what we do at the law school as stewards of justice and every day. Thank you.
That was great. Thank you so much for
you.
that. A couple questions that we had a little bit before that people were asking. Is it common for, actually, how do I say this? Is it common for state courts to have such, was this one of the first instances where the national court had essentially taken the state's court's wards and reused them to push something through? And is that essentially what the state court's goal is in time, especially coming from a state as democratic as Massachusetts?
So as somebody who has worked formally at an appellate court, I would say yes, definitely state courts are in this dialogue, and they are not only writing opinions to deal with the case at hand, but also seeing what its legacy is going to be afterwards. You know, how will a state court's decision be taken if this particular issue is so controversial that other states might want to have a similar conversation in their jurisdiction, and then maybe it percolates up to the Supreme Court. So when you're writing an opinion for a judge, or if the judge is putting together an opinion, you're always mindful of like, impactful could this decision be? And do we want to be a forum where we can set up a dialogue or a template or a roadmap of some of our ideas about this issue, in addition to, of course, addressing the harm of the litigants that are before us. So definitely, that is always something that's in play. Yeah, that's a very good question.
That's perfect. And I know a lot of people were saying about how, obviously, at the national court level or at the Supreme Court level, there's a lot of, in this area especially, caution with how that could potentially change. How does Massachusetts stand to fight against that as a state, if it was to go in a direction that's opposite maybe of where our state's beliefs tend to be or laws tend to be?
I think that Massachusetts is actually positioned to be a very influential state because of a lot of the issues that percolate to the SJC are then reflected in national debates. I think that Massachusetts, and this is not a judicial issue, but I'll just give an example. For instance, in the area of marijuana legalization, Massachusetts is now one of the first country to embrace that idea, and now we have other states along with it. It's a patchwork of conversation on that. It's going to percolate at some point up to the federal level, and Massachusetts is going to have an influence in its political system because of that. Same thing you'll see with cases going up to in the judicial branch that deal with really important issues, maybe with healthcare, maybe with some sort of tax reform or something like that. You'll always have some, it's a good venue to be able to test out a particular viewpoint and then see if it will end up affecting the conversation nationally, and then maybe it'll take 10 or 20 years then to get to the Supreme Court, but it might be influential in that regard, yes.
That's amazing. You talked a lot about, obviously, systemic inequality, and that's extremely popular now. I shouldn't say popular, but extremely in everyone's minds right now. And I feel like, especially here at UMass Dartmouth, with our undergrads, we spend a lot of time talking about it from the social science perspective. What are ways that people can look at it from a law perspective to really create change, to kind of get rid of systemic inequality, as you mentioned in this case?
Yeah, that's a really good question. I could teach a whole semester's worth on that one. What I would say is that there are two viewpoints about the law right now in terms of addressing equality. One is called formal equality, where the law will be articulated to say everyone should be treated fairly. And that is an important value that we have. Everybody should be treated fairly in this particular context or in this particular way. And then there's another concept that's a formal equality. It sounds very formal. The grammar is formal in stating that rule. But then you have another concept called substantive equality, which is saying that's great to have a law that's formally crafted to be saying everybody should be treated equally, but we can't forget that the law has had a history of marginalizing people already. So we then need to have laws that also not only do the formal equality stuff, but also laws that address things like, the criminal justice reforms that might already have some consequences for certain people of color, more so than others. So this is the harder kind of equality that the law has to figure out how to address before we can get to a point where we can say everybody should be treated equally. Because if we say that right off the bat, there are people who have already been mistreated unequally for such a long time that they can't even get up to the starting point of being treated equally, according to a formal equality viewpoint. So that's the really hard stuff that I struggle with in my research, along with other academics, on like, how do you define laws like this? What's part of that system? How does those laws add up to affect that kind of substantive inequality? That's the systemic inequality right there. And how do we slowly, bit by bit, not only address how unequal that is, but talk about the ways in which we would go about trying to change that? Do we do that legislatively? Do we do that judicially? Do we rewrite parts of a constitution? How do we do that? So that's the challenging part in the law. I think this is where the law will talk to people in the law circle or law academic area will have to talk to the social scientists and political scientists to then kind of get together and put our minds together to figure out how to solve this issue of systemic inequality. Because I think the social scientist perspective in most of the literature there, or the discussion there, is focused on the phenomenon of systemic inequality and the consequences of it, but not yet looking at the finite laws and the system of laws that create that kind of systemic inequality. And that's where the lawyers and the judges and the politicians and the legal academics like me come in to try to do that fine work. And that's the next step, I think, is the more synergy between the disciplines.
That's amazing. That's a great answer. I appreciate that. Yeah, that's basically what we have for today. Again, I want to thank you again. You're an asset to the university. We appreciate what you do for all of our students, and we hope to have you back on a different topic because we all learned a lot, and I think this was great. So thank you so much for your time.
Thank you so much, and happy homecoming 2020.
There it is.
Take care. Yeah. Take care and be safe, and have a great homecoming and enjoy.
Awesome. Thank you so much. Have a good one. Thank you for attending, everybody.
Thank you.
Bye.